Thank you.
Thank you. All right. Everybody, welcome to the courtroom at McGeorge School of Law, and welcome to the Global Lawyering Skills 48th Annual Global Lawyering Skills Top Advocate Final Four competition. Before I tell you about our case this year, a few words from our eminent dean, Michael Hunter Schwartz.
Good evening, everybody. It's great to see all of your faces, not just the top half. And this is the first time in 2 years we've been able to gather and do this in person. And so I'm beyond thrilled and excited and on the edge of my seat to watch our brilliant advocates in action. It really is an amazing experience to see our students shining like this. And what you may not know is that they shine so bright that actually, I suspect, as the justices have said every year we've ever done this, that actually there are a lot of lawyers who will not live up to the way you're going to perform tonight. And so it's a really great moment. I want to make a special welcome to our advocates, to our Best Brief Award nominees, to students' family members, friends, supporters, and a special welcome to our Pacific Legal Scholars who traipsed up here from our campus in Stockton to join us today. The best thing of all is that I get to introduce our 3 judges for tonight. First, recently retired and former presiding judge of the Sacramento Superior Court, Kevin Culhane. I actually saw him the day before his last day. He seemed awfully happy about it. Second, retired presiding justice of the 3rd District Court of Appeal, Art Scotland. He is actually the person who played, along with Judge Consuelo, who played a large role in me ending up coming here as dean. They took me out to lunch and wouldn't let me leave until I committed. And then third, 9th Circuit Court of Appeals Judge, Connie Callahan. And all 3 of them, what I will tell you, are McGeorge grads, class, I'm not going to tell you which is which, class of 74, class of 75, and class of 76. They are all incredible supporters of the law school. There probably isn't a month that doesn't go by that I see and talk to Judge Culhane. I mean, actually, Judge Callahan is actually the one that I see the most of. All 3 of them serve on the law school's dean's cabinet. And so they're always advising me on how to try to make the law school better. And 2 of them are former regents of our university. So these are people who serve and are brilliant at the work that they do, and we are so lucky that they are here tonight to judge tonight's arguments. Thank you all. Have a great time. You'll have to work to have as much fun as I will, but do your best.
Thank you, Dean Schwartz. All right, I have the great pleasure of telling you a little bit about tonight's matter before the 14th Circuit Court of Appeals. This is the culmination of a full year of our 2nd year classes efforts in the Global Lawyering Skills 2 program. This problem in particular, they took up in January. This problem involves Dr. Peter Foster, who is a doctor of surgery at the eminent historical institution of Dragontown University in the state of Keystone. Dr. Foster, in addition to his teaching duties, also maintains a personal blog. And on that blog, he published some fringe theories for treatment of epilepsy using chiropractic methods. A doctor out in the world read this suggestion and actually implemented it with a patient who ended up dying. Thereafter, there was severe blowback to Dragontown University, and donors threatened to stop donating, and students were in an uproar that one of their eminent physicians on the medical staff published something so fringy that caused people harm. Ultimately, the university fired Dr. Foster, and he brought an action in the Keystone District Court for a violation of his First Amendment free speech rights and a violation of his 14th Amendment due process rights. Dragontown University brought a motion to dismiss thereafter, and for the lawyers in the audience, you don't need to know what that means, but everybody else, that means his case was over when the court said, granted. So Dragontown's motion to dismiss was granted, and now Dr. Foster has taken the matter up on appeal to the 14th Circuit Court of Appeal, which is where we are tonight. So, representing our parties tonight in this proceeding, for the plaintiff appellant, Dr. Foster, John Gutierrez, Allison Ornelaz, and for defendant appellee, Dragontown University, Kathryn Lerseth, and Heather Mills. So without further ado, I present to you the matter of Dr. Peter Foster versus Dragontown University. So, all rise. The United States Court of Appeals for the 14th Circuit is now in session. You may be seated.
Good evening, ladies and gentlemen. Welcome to the 14th Circuit. We are here today in the matter of Dr. Peter Foster versus Dragontown University, case number 01265. We're ready to proceed, and our appellant's ready.
Yes, Your Honor.
All right. We're ready.
Good evening, Your Honors, and may it please the Court. My name is John Gutierrez, representing Plaintiff Appellant Dr. Peter Foster, and I will be addressing the First Amendment argument. My co-counsel, Allison Ornelaz, will be addressing the 14th Amendment argument, requesting 3 minutes for rebuttal.
All right. Am I understanding you correctly that your co-counsel will be using the rebuttal time? Or?
No, just myself, Your Honor.
Okay. All right. We're ready then?
Thank you, Your Honor. Your Honors, this case is about protecting freedom of speech on American universities. In 2021, Dr. Foster was shocked to learn that he had been summarily terminated from his professorship at Dragontown University after publishing his opinion on an online blog. Now, petitioner requests this court reverse and remand the lower court's motion to dismiss against Dr. Foster.
Let me interrupt you for a moment. When you're looking at this record, the question is whether he spoke as a citizen or spoke as an employee of the university.
Yes, Your Honor.
And he used his university email. His bio was on the website. Why doesn't that indicate kind of an imprimatur by the university? The fact that it was an implicit approval of his views by the fact that his name was associated with it.
Yes, Your Honor. Garcetti's categorical deprivation for First Amendment protections of academic speech has never been triggered by markers or identifiers on websites. In fact, the Supreme Court's case in 2004, City of San Diego versus Roe, held that a Garcetti analysis, which would have found the professor spoke pursuant to his official duties, was not implicated by a uniform on the personal website.
Well, hypothetically, let's just say Mr. Foster, Dr. Foster made these comments in his teaching his class. Would that be employee speech?
Your Honor, it depends, but on those facts, that would probably most likely meet Garcetti's rule because, as Garcetti versus Ceballos held, it's the context and manner of the speech that triggers a Garcetti analysis, not the substance of the speech. And in this case, the facts here do show that Dr. Foster's speech was not made pursuant to his official duties. As we can look on page 12 of the record, Dr. Foster spoke on a private, self-funded blog that was published to an indiscriminate online audience not affiliated with the university for any reason. And so for those reasons, Dr. Foster's speech does not rise to the higher standard that is required for a Garcetti analysis to be applied in the present case.
Does it matter that someone read the blog and then treated her patient with what turned out to seem to be quackery or was sued for malpractice? Does that even figure into the equation here? Is that something we should think about?
Your Honor, for Garcetti purposes, that is not an outcome determinative fact that would warrant a categorical denial of Dr. Foster's claim in the present case.
Can I ask you a quick question, counsel? In your briefing, you contend that there's an academic speech exception to the Garcetti rule. Let's say this panel agrees with you so that we're now going to balance the interest under the Pickering test. Particularly for a medical school, if you have a response to the proposition, at least for a medical school, they've got a very weighty interest in following the science, if I can use that terminology here. So that even if you were going to weigh things under Pickering, isn't that a difficult place for your client to be?
Yes, Your Honor. In the record, both parties have stipulated 2 disruptions that occurred on the university campus. We can take each of those disruptions line by line and, based on case law in the circuits, find that Dr. Foster's public interests and the matters raised by his speech do outweigh those interests. Just one, for example, the parties stipulated that just a single class was canceled during the protest. However, we can look to Hardy versus Jefferson from the 6th Circuit Court of Appeals, in which diversity community leaders threatened to pull back enrollment and disrupt donor funding. We can also look to Silva versus University of New Hampshire, in which an entire class was canceled for a whole semester as a result of a professor's insensitive language towards diversity and insensitive sexualized language. In those particular cases, the Pickering-Connick test was applied, and it found the professor's speech did touch on matters of public concern that outweighed those disruptions.
Okay, so if we find that your client is an employee, you're telling me that that isn't dispositive and you don't lose, but that's putting one nail in the coffin, right? So tell me what has to happen in order for you to prevail, and what issues can you lose on and still prevail?
Yes, Your Honor.
Roadmap.
Yes, Your Honor. Even if Garcetti's categorical rule does apply, even if this court does find that Dr. Foster spoke pursuant to his official duties, his speech would still be protected because the academic speech exception would apply. In the present case, the academic speech exception is something, as a matter of public policy, that this court should adopt because it most consistently represents the Supreme Court's current posture towards academic speech on American universities.
So your client was a member of the Department of Surgery,
yes,
correct? And it would seem to me that chiropractic has nothing to do with surgery, and in fact, it's unrelated to his scholarship and teaching duties. Would I be wrong in thinking that?
Well, Your Honor, in the current facts right now, although it touched on chiropractics, Dr. Foster, in the record, on page 12 of the record, is a professor of surgery. He talked about it in the capacity as it being an alternative to invasive surgeries. But moreover, even without that, the blog post taken as a whole touched on issues in the American medical system. To qualify for the academic speech exception, Demers from the 9th Circuit articulated that it can relate to scholarship or matters of public concern. In either of those scenarios, it relates to research from the medical field or issues with pharmaceuticals and invasive surgeries.
You brought up the issue of public concern.
Yes.
And in Garcetti, that court talked about the public's interest in receiving well-informed views of public employees. Is that the test we should decide? Whether your client's comments were well-informed of you?
For Garcetti, Your Honor?
Yes.
So, Your Honor, Garcetti's
5 minutes.
test is triggered by a higher standard of the context and manner of the speech itself. The Garcetti test does not concern the substantive matters of the speech. Rather, that is reserved for a Pickering-Connick balancing test. In the present situation, because in Garcetti, the acting deputy district attorney published his problematic language in an official office memorandum for his supervisors and for judges on a case sentencing recommendation.
I don't know if you're answering my question. Is one of the tests whether it is a well-informed view?
No, Your Honor, that is not something that should be considered in triggering the categorical test from Garcetti.
So, you speak as if this, that there is an academic speech exception. Aren't you overstating it on some level, that it's still sort of being debated, that the Supreme Court leaves it possibly open? But tell me why you're so certain that there's this academic speech exception.
Yes, Your Honor. We can see that the academic speech exception originated from dicta in a Supreme Court decision, but since then, the Supreme Court itself and the circuits have consistently reaffirmed their posture towards the importance of academic speech to be regulated narrowly. In the Supreme Court's 2014 decision of Lane versus Franks, they reaffirmed that our nation is deeply committed to safeguarding academic freedom, which is transcendent value to all and should be regulated narrowly. To adopt a categorical rule would snub that posture right now.
What is the test that we should apply to determine whether a particular comment falls within the academic?
Yes, Your Honor. The test this court should apply is the Pickering-Connick balance. Actually, may I clarify your question, Your Honor? Was that whether it falls pursuant to their duties or just for this case itself?
For this particular case.
Thank you, Your Honor. This court should apply the...
Actually, why not generally speaking? Give us a framework. What is the test we apply, and then talk about the facts of this particular case.
3 minutes remain.
Yes, Your Honor. This court should use the Pickering-Connick balancing test to determine whether Dr. Foster's speech raised matters of public concern that outweighed Dragontown University's efficiency interests. And looking at it as a matter of fact, we see that Dr. Foster's speech did raise issues of public concern because, as we see on page 14 of the record, the blog entry produced a robust dialogue regarding invasive alternatives to surgery and broader issues in the American medical system. It was the Supreme Court's decision in Connick itself that articulated that any matter of political, social, or other concern to the community can qualify for an issue that raises matters of public concern.
But if it can be shown to be, I think as my colleague Judge stated, that science is important, if it really falls into quackery, that it just is, you know, if you stand on your head and you turn to the west, that should solve your problem. If it really is quackery, which there could be an argument here made, does that still withstand scrutiny under your Pickering test?
Yes, Your Honor. Nevertheless, on page 14 of the record, we see that on the one hand, yes, some members of the medical community disregarded these beliefs as fringe, but on the other hand, other members of the medical community and public at large backed these beliefs and felt they were important, felt they raised important matters of public concern. And moreover, in Connick, the Supreme Court held that the speech in question cannot be parsed. It all must be taken together. So yes, Dr. Foster did have some beliefs that had concerns from both sides, but on the other hand, the speech touched on broader issues that are prevalent in the American medical system, pharmaceuticals, over-reliance on invasive surgery, and all that as a black letter law must be taken together and cannot be parsed away.
Is there any limit on this academic exception?
On the academic speech exception, Your Honor.
1 minute remains.
The academic speech exception, Your Honor.
If so, what is the limit?
The limit would be whether it applies to scholarship or matters of public concern. But as we see on page 14 of the record, again, because it's produced a robust dialogue with members of the community on a prevalent issue in the United States right now, the issues of medical costs and pharmaceuticals, invasive surgeries, this would be the academic exception here. And for those reasons, because it raised so many issues of public concern, it does outweigh the disruptions to the university's efficiency interests.
Are you abandoning your argument that he's an employee or not an employee, or is that your first line of defense? He's not an employee. It's not employee speech.
No, Your Honor, it's still correct that it's not employee speech. We uphold that argument, but our argument is even if it is found to be employee speech, it is still protected by the academic speech exception because that rule would cancel out the categorical rule.
All right, thank you, counsel.
Thank you, Your Honors.
May I approach, Your Honors?
Yes,
Thank you.
please do. We're ready.
Good evening, Your Honors, and may it please the court. My name is Allison Ornelaz, co-counsel for Appellant Dr. Peter Foster, discussing his 14th Amendment claim. This case is about the flagrant infringement of a U.S. citizen's fundamental liberty interest in his reputation without the constitutional protections of due process. This court should vacate the district court's order and deny Dragontown University's motion to dismiss for two reasons. First, Dr. Foster's reputational liberty interest was deprived by Dragontown University as their press release contained stigmatizing statements that extinguished his tangible interest in future employment.
Well, let me ask you, does Dr. Foster have to show that Dragontown's press release was false in order to have a claim for defamation? Can an opinion, which we have that letter, can an opinion, which cannot be shown to be factually false, an opinion is just what someone thinks, be the basis of a claim for defamation?
Yes, Your Honor, an opinion can be defamatory under Restatement Second of Torts, Section 566. An opinion is defamatory when the underlying facts to support those opinions are not disclosed, leaving a reasonable reader to conclude that the speaker knew of information to support those allegations. And here, although Dragontown University did include some facts as stated on page 22 of the record, they drew attention to the media attention surrounding Dr. Foster. However, the 1990 U.S. Supreme Court case Milkovich v. Lorraine Journal Co. held that where facts are disclosed supporting opinions, but they are either inaccurate or incomplete, they're still liable for those opinions. And as Dragontown's press release did not include any additional facts to support their allegations, they would still lose under this true or false analysis.
Well, what was false about it? What was false?
Your Honor, what was false was they were claiming that they questioned his competence. And here, although these would be more of opinions, as they're a very subjective belief, we would still assert that Dr. Foster's competence was not to be questioned, it was not false. And turning back, the second point I would like to make is Dr. Foster, his right to a due process hearing was violated.
Before you get to that point, if we go back to Paul v. Davis, United States Supreme Court, the language says there's no constitutional doctrine converting every defamation by a public official into a deprivation of liberty within the meaning of the 14th Amendment. There was some dicta about an absence of loss of public employment. But why should we find an infringement of a liberty interest in one's reputation when the statement, even if it's construed to be defamatory, is true?
Your Honor, the statements that Dragontown University asserted would not be true, as it is still a subjective belief. And under Paul v. Davis, the court applied the stigma plus test and found that one suffers a deprivation to their reputational liberty interest when statements are stigmatizing and extinguish or alter a legal status.
Oh, but if they said he was a child molester and there was no evidence, that he was a convicted child molester and he has no convictions, that would be a false statement, right?
Yes, Your Honor.
But here, these opinions, what's false about it?
Your Honor, they can be proven neither true nor false. In the facts, we do not have anything in the record to support that he was in fact an embarrassment, or he was in fact incompetent, or the statements were in fact insane. It's a subjective belief.
That wasn't the university statement. All it said was it parted ways due to his dissemination of advice inconsistent with the university standards.
That's correct, Your Honor. However, they did include the alumni letter attached to their press release. And the Ninth Circuit 2002 opinion, Flowers v. Carville, They looked and applied the republication rule to two individuals of the Clinton smear campaign and found that by merely repeating defamatory statements that the alleged mistress of President Bill Clinton had potentially doctored these recorded phone conversations, merely repeating those opinions, even citing them to the news agencies that reported them, they had adopted the statements as their own and were just as liable as the original speaker.
So if they hadn't put that letter, if they hadn't affixed that letter, would you have a claim?
No, Your Honor, we would not have a claim under the stigma plus test, as nothing in the face of their opinion on page 21 of the record was stigmatizing.
So to accept your position, we have to believe that by affixing the letter, they are adopting it as their view.
Correct, Your Honor.
Even though they don't say that, but they put the letter there.
Correct, Your Honor. And these statements are stigmatizing under the 2007 Eighth Circuit opinion, Brown v. Simmons, which held that a stigmatizing statement is one that damages one's good name, reputation, honor, or integrity. And prior to this press release being published, Dr. Foster did have a good reputation. As noted on page 12 of the record, he was well-liked, viewed as an excellent professor and a skilled surgeon, 3 times winning a Student Appreciation Award at a worldwide known medical university. However, these statements have called into question his competency and capabilities in the medical community.
So what's the plus in the stigma plus?
The plus is the extinguishment of his tangible interest in future employment. And here, as noted on page 17 of the record, Dr. Foster has been unable to find employment in the medical field since his termination and reputational injury. And the 2000...
Would termination alone be enough? Would that be enough per plus?
Your Honor, if he was asserting a property interest, however, here he is asserting a liberty interest in his reputation. So here he does have to show the tangible interest in his future employment.
Let me ask you this. One of the findings of the district judge that issued the opinion you're appealing from is that there wasn't any evidence of efforts to get work or loss of work. Can you speak to that? And how does that play into this part of your analysis?
Yes, Your Honor. As noted on page 17 of the record, which is in his complaint, and when we are looking at a 12B6 motion, we are to take the complaint at face value as correct and look in the best light of the non-moving party. And on page 17 of the record, he does state that he has been unable to find work in the medical field since the press release was published. And if we are to look in the best light most favorable to the non-moving party, we must imply that he at least has made the effort to find this employment.
From your perspective, at least on this claim, that by itself mandates a reversal. You're saying the trial court judge, could not make the finding he made on a 12B6.
Yes, Your Honor, especially when we are looking at the 2002 Ninth Circuit opinion of Ulrich v. City and County of San Francisco, where they found that the close link between an employer's stigmatizing statements and the employee's inability to find employment satisfied the stigma plus test and found that one suffers a deprivation of their reputational liberty interest. And here, as Dr. Foster has in fact asserted in his complaint, both the statements were stigmatizing and they have caused him to be unable to find this future employment. He is satisfied a showing under the stigma plus test.
If you have the stigma plus test satisfied for purposes of the 12B6 ruling, can you speak to the issue of whether your client opted out of the due process hearing, invited to come and speak to the dean, didn't respond?
No, Your Honor, he did not waive his right to a due process hearing. The 2011 Ninth Circuit Court Walls v. Central Contra Costa Transit Authority held that a constitutional waiver of a constitutional right must be a knowing and voluntary act, and federal courts must make every reasonable presumption against finding such a waiver, and it must not be implied. And although he did receive one email from Dean Berman, his silence should not be implied as a knowing and voluntary waiver of a constitutional right.
Well, if the email, hypothetically, if the email had said, please contact me because I want to set a time where we will discuss your comments on your blog and said, and be prepared to discuss what your side of the story is. And he didn't respond. Would that be a different situation?
No, Your Honor, under that situation, they would still not be comporting with due process requirements.
Well, what are you expecting, a whole jury trial?
No, Your Honor, at least give proper notice, and in the 1985.
But if he said, you come in and I want to hear your side of the story, isn't that giving him some due process?
Your Honor, under the 1985 U.S. Supreme Court case Cleveland Board of Education v. Loudermill, the court held that a tenured employee is entitled to receive notice of the allegations against them, the evidence to support those allegations, as well as the opportunity to respond. And prior to a hearing, Dr. Foster was entitled to the notice of what they would be meeting about and an explanation of the evidence, so he was able to come prepared to that meeting with full knowledge of what would be discussed.
Counsel, you started your argument using a very strong word. This was a flagrant violation of due process. And that's a pretty strong word when reasonable minds might differ on this subject, when you have the fact that, didn't he have knowledge of what they were referring to the allegations against him? Those are the allegations in the letter that was attached to the statement by the university. Didn't that give him notice? They said, we want to talk to you about it. To talk to you about it, doesn't that indicate an opportunity for him to explain why they have no merit, et cetera? And then also the cases stand for the proposition that you have to do some balancing, so that you have to think about the burdensome nature of a full evidentiary hearing and the cost of that, et cetera, if you had to do that every time. So is this truly so flagrant, or is it just you're making an argument that the balance should be in your client's favor?
Your Honor, to address your first part of your question, I would argue that this is in fact a flagrant infringement of his constitutional right, as notice and requirements under due process just was not proper. When he has been a tenured employee for 5 years, he deserved to have at least some.
But arguably, there is case law out there that says sometimes you can act quickly because if you think people are going to die. And so in the backdrop, we have here that someone used his alternative quackery and the patient died. So that would be, that's what I would argue if I were Dragontown. So, you know, your statement that you want all of this due process and their statement that people's lives are in danger, isn't that a factor?
Yes, Your Honor. However, the U.S. Supreme Court, the U.S. Supreme Court's Cleveland Board of Education also held that where an employee presents a significant hazard to the employer, they are entitled to suspend them with pay pending a hearing. And if we look at the Matthews v. Elridge balance test, which holds that one is entitled to one is entitled to a formal name-clearing hearing, where their private interest is erroneously deprived by inadequate procedures and the government has an insubstantial interest and burden, Dr. Foster's interest was significantly greater than Dragontown University's. And here, although Dragontown University did have an interest in their operational efficiency, as well as ensuring that enrollment wasn't discouraged, they also had this interest in Dr. Foster's constitutional right. And this is also consistent in Cleveland Board of Education, which holds that employers have an interest in not erroneously depriving their employees' constitutional rights. And when we're looking at the balance, Dr. Foster's private interest in his constitutional fundamental right of his reputation and the erroneous deprivation he has received, it is insubstantial to show that.
Seems to me you're missing your best argument. This email doesn't say anything that gives you any idea about what's going to happen. It sort of seems very casual. That would be my argument.
Correct, Your Honor. The email was vague and unspecific. And in Ryan v. Illinois Department of Children and Family Services,
And it remains.
the Seventh Circuit held that where the employees asserted that not all of the allegations were present, they still found that enough were. And here, no allegations were present in her email, so it was inadequate under due process procedures. And accordingly, in balance, they could have merely satisfied all of their interests by just suspending him with pay pending this hearing. And as the whole purpose of a due process hearing, as held by Cod v. Velger, is just to provide an opportunity to clear one's name. He was deprived of his constitutional right to do that by inadequate procedures. And therefore, Your Honors, it is clear Dragontown University violated Dr. Foster's 14th Amendment rights. And I therefore respectfully request the court vacate the district court's order and deny Dragontown University's motion.
Time.
Your Honor, I see my time has elapsed. May I please finish my sentence?
Yes.
And I request that the court vacate the district court's order and deny Dragontown University's motion to dismiss. Thank you.
All right, we're ready to hear from Appellee Dragontown. Yeah.
Good evening, Your Honors, and may it please the court. My name is Heather Mills, and I will be representing the appellee, Dragontown University, on the First Amendment issue, and my co-counsel, Kathryn Lerseth, will be representing the appellee on the 14th Amendment issue. We respectfully request that you affirm the district court's ruling. Dr. Foster is not free of the consequences of his actions. Dr. Foster's unsubstantiated medical advice led to the loss of life of a Keystone community member.
Oh, wait. All right, there was a doctor there. I've got to call you out on that one. There was a doctor that had a duty of care to a patient, and the fact that the doctor followed what you would call quackery, that's not Dr. Foster's fault. There's a break in causation there.
Your Honor, Dr. Woolley relied heavily on the advice provided by
Dr. Woolley went to medical school and did a residency and has passport. So what you're saying that Dr. Woolley didn't have any responsibility to look into that?
I apologize. No, Your Honor, we're not saying that Dr. Woolley did not have any responsibility, but we are saying that Dr. Foster's unsubstantiated medical advice did play a role in that situation.
Did he kill any other people?
No, Your Honor, he did not.
Okay.
However, it did require Dragontown University to act swiftly. We respectfully request that you affirm the district court's findings for three main reasons. First, Dr. Foster was acting pursuant to his official duties to engage in discourse, falling squarely within the Garcetti analysis.
Counsel, let me interrupt you for a moment. Given that Dr. Foster's website contains photos and articles about his vacations, it contains satirical and humorous pieces, wouldn't any reader understand that this website, including the blog, really is speech of a citizen and not a university employee?
No, Your Honor. Although there were personal aspects of this blog, he also utilized his blog to engage in discourse. He posted peer-reviewed medical journals. He actually used the website to foster scholarly debate on topics of medical school.
Did he do any of this in his teachings in class at the medical school?
No, Your Honor, he did not teach on any of these issues. However, as seen in the record on page 12, one of his official duties was to engage in discourse in furtherance of the missions of the university.
Doesn't the First Amendment mean sometimes that we have to hear things that we don't want to hear? And it means that sometimes universities have to allow dialogue that maybe they would rather not have. And so why isn't this just the woke mob coming after Dr. Foster here, that the university is just wants this to go all away? And if they fire Dr. Foster, even if he has a right to say the things that he's going to say, why isn't that what's happening here?
Your Honor, under Garcetti versus Ceballos, the Supreme Court held that when a public employee is speaking pursuant to their official duties, that they do not receive First Amendment protection. In the present case, Dr. Foster was speaking pursuant to his official duties to engage in discourse. Dr. Foster acknowledged on his blog, on his website, that which hosted his blog, that the purpose of his website was to engage in foster debate about topics of medical concern. Discourse can be defined as debate. This case is further analogous to Abkarian versus McDonald, where the Seventh Circuit Court dealt with a professor of surgery who made comments about overprescription of medications. In that case, the court held that the professor was speaking squarely within their official duties and therefore met the Garcetti analysis. Similarly, Dr. Foster is a professor of medicine, is an assistant professor of medicine and a faculty member in the Department of Surgery.
Do you concede that a physician's theories on the treatment of epilepsy is a matter of public interest, public concern?
Yes, Your Honor, it is a matter of public interest. However, Garcetti requires that a plaintiff prove both that they are speaking as a private citizen and on a matter of public concern. So it isn't sufficient just for Dr. Foster to prove that he is speaking on a matter of public concern. He must also be doing so as a private citizen. In the present case, Dr. Foster was speaking pursuant to his official duties.
So if we find that he's not an employee, you lose, right?
No, Your Honor.
If he's not speaking as an employee.
If he's not speaking as an employee pursuant to his official duties, the court would then turn to the Pickering-Connick balancing test. And in that test, Dragontown University's interest still substantially outweighs that of Dr. Foster's.
Let me engage you just on that last point for a second. Sort of beginning with the proposition, the university in the broad sense is where you expect, wide divergence, strong feelings. It all gets debated there all the way back to the time of Socrates, right? Darwin, was at one time ridiculed. Dr. Salk, responsible for the polio vaccine, was dismissed as a quack at one time or another. What the university, is a university, you really think their interest in, maintaining the donor base, et cetera, outweighs the speech here?
Your Honor, in the present case, the distinction is that Dr. Foster jumped from hypothesis to conclusion. He did not engage in the scholarly process. He did not provide sources, citations. He didn't have research, facts, or reason, but rather he urged practitioners to take on a course of conduct outside of his area of expertise without having any sort of basis to ground his claims. Further, as seen in the record on page 13, several Dragontown University faculty and those in the medical community held that Dr. Foster's statements were not grounded in sound medical science.
Is that controlling here? I mean, what they thought? That's all I was getting at, that he didn't get the hearing he claims he's entitled to when we get to liberty interest. Have that debate. Didn't happen here, right?
Your Honor, could you rephrase your question, please?
Yeah, it's probably sufficient that, you had these other doctors that signed on. They don't think he's right. Clearly, they don't think he's right. He presumptively thinks it is, but that someone decided that was the end of the ball game. 10 against 1, I guess. But is that consistent with his free speech rights, you think?
Your Honor, in Garcetti versus Ceballos, the court held that when a public employee is speaking pursuant to their official duties, that they do not receive First Amendment protection. Here, Dr. Foster acknowledged in his complaint in the record on page 17 that one of his official duties was to engage in discourse. Dr. Foster further acted pursuant to this official duty to engage in discourse when he posted on a blog about a topic of medical concern. Even if this court were to adopt an academic exception, Dr. Foster's speech falls outside the scope of such an exception. There are 3 categories that have been recognized by the court. In Garcetti versus Ceballos, the dissent in that case acknowledged the categories of classroom instruction and of academic scholarship. And the lower courts have added a 3rd, which is administration. In the present case, I will turn to the first category of classroom instruction. Unlike the Sixth Circuit's holding in Merriweather versus Hardtop, concerning in-classroom speech, Dr. Foster never taught on any of these beliefs, nor had any of his students heard about his fringe beliefs.
Well, so I guess, so Dr. Foster's blog didn't in any way interfere with his teaching at Dragontown, did it?
It did interfere with his teaching in Dragontown in that it caused a disruption to the university. There was a sit-in that lasted several hours and required a class to be canceled. It extended broader to the undergraduate campus as well, with undergraduate students calling irate about Dr. Foster's conduct.
So just because someone protests what someone thinks, that automatically, that's a disruption? What do we weigh that against? If he's got a right to say something and it's, what is your position? Is what he says, is it a public concern?
Your Honor, yes, what he said was a matter of public concern, but again, he has to prove both that he was speaking as a private citizen and on a matter of public concern.
Counsel, when you're looking at the Pickering conduct, let's assume that we conclude that there is an academic exception. Mm-hmm. And let's assume that we apply the Pickering conduct balancing test. If we were to conclude that the university's interest is stronger than his interest, it seems to me common sense would be that might stifle academic speech in universities throughout the country when universities are supposed to be the marketplace for ideas. So tell me, if that's one consequence of a ruling, what about the university's interests make it greater than that particular potential consequence?
Yes, Your Honor. There are two things. One, that there was a significant disruption to the university, and that it started with a sit-in that lasted several hours and resulted in a class being canceled. It grew to the undergraduate campus with undergraduate students calling irate about Dr. Foster's conduct. It grew again with a prominent donor threatening to withdraw donations, and it grew broadest to the larger Keystone and medical community with 10 prominent physicians and alumni calling for Dr. Foster's dismissal.
Well, I think it's interesting, though, that Dragontown doesn't have a policy on social media, right? So why couldn't Dr. Foster conclude from that the fact that they don't have a policy reflected an understanding that employee speech did not extend to a personal blog?
Your Honor, Dr. Foster was speaking pursuant to his official duty to engage in discourse in furtherance of...
But does the university have a policy on having personal blogs?
No, Your Honor, the university does not currently have a social media policy. However, they are intending to work on one.
Well, okay, but Dr. Foster gets the benefit of that they don't have one. So why should he think that he's doing employee speech?
Your Honor, because Dr. Foster still has an official duty to engage in discourse. This would just merely be digital discourse, but it would nonetheless still be discourse. Additionally, Dr. Foster utilized his official Dragontown University email, which appeared at the bottom of each and every blog post.
That's not how he didn't do students on that blog, right?
No, Your Honor, he did not have students on that blog. However, if readers wanted to further engage in discourse with Dr. Foster based off of the posts that he made, they would have to email him at this official university email.
Are you suggesting that anything he put on that blog that touched on medicine, was now employee speech because it constitutes quote unquote discourse on something?
Your Honor, Dr. Foster had the official duties of engaging in discourse in furtherance of the missions of a public research institution. The issue here is that Dr. Foster made irresponsible statements.
So the discourse has to be something that your employer likes. Is that what you're saying?
No, Your Honor.
Irresponsible basically means I don't like what you say. So, and the First Amendment says we have to listen to things that we don't like.
Your Honor, the American Association of University Professors, who is a fervent proponent of academic freedom, in their declaration held that a professor is free from fear of termination when they reach a conclusion in a scholar's spirit and by a scholar's method. Here, Dr. Foster jumped from hypothesis to conclusion. Dr. Foster's speech would not have been limited had he been asking the university for additional funding to research this idea so he would have that foundation to bolster his claims. Additionally, Dr. Foster's speech would not have been limited had he been urging practitioners to funnel their research into this hypothesis. The issue here is that Dr. Foster made statements on an area outside of his expertise without grounding it in sound medical science. He was not building on science, but was rather utilizing his affiliation with the university as his sole semblance of credibility.
If no one had complained, would Dragontown have been monitoring his blog?
Your Honor, the Dragontown potentially could have monitored his blog. However, as it is clear in the record that the faculty had not seen his blog up until it went viral. However, that does not mean that they wouldn't have come across it at some point or another. The issue here is that the university hasn't.
So if you're right about this, they should complain about it even if no one else complained, right?
Your Honor, the issue is
1 minute remains.
the university has an interest as a source in its efficient and effective fulfillment of its duties to the public, as seen in the Supreme Court case Lane versus Franks. The university has a duty to the public as being a source of safe, accurate, and reliable medical information.
So even if no one had complained, they should monitor that kind of language. If you're telling me, if the speech is the speech, the fact that other people complained isn't the factor, that's not what you're relying on, right?
Yes, Your Honor. The university should have a sound social media policy and further follow up with Dr. Foster's statements that he is posting. That is true. However, that does not change the fact that he was speaking pursuant to his official duties to engage in discourse when he posted on this blog. Dr. Foster's speech further does not...
Time.
May I briefly conclude?
Yes.
Thank you. We ask that you find that Dr. Foster's actions have consequences and that you affirm the district court's findings that Dr. Foster's First and 14th Amendment rights were not violated. Thank you.
Thank you.
May I approach your honors?
Yes. You may proceed.
Good evening, Your Honors, and may it please the court. My name is Kathryn Lerseth, and I am co-counsel for the appellee in this matter, Dragontown University, and will be addressing the 14th Amendment issue. This case is about a public employer's right to utilize legally established procedures to protect itself from the destructive consequences of an employee's untoward conduct. Through this appeal, appellant seeks to unjustly undermine the constitutionality of the measures taken by Dragontown in terminating his professorship. The district court's decision that appellant failed to state a claim upon which relief could be granted should be affirmed for the following reasons. Under a de novo standard of review, appellant's 14th Amendment claim fails as a matter of law because Dragontown issued only truthful statements about him and acted in accordance with procedural due process when terminating his position.
Why did the universities attach the doctor's letter to its statement that it was just discharge, or they parted the ways? Why did they do that?
Your Honor, the medical malpractice trial that arose out of appellant's blog post was really big news in the community, and so they attached the letter to provide context for its decision. As my opposing counsel mentioned, he was...
So basically they endorsed it. You don't attach something unless you endorse it. I mean, why would you? So, I mean, it just seems like that gives it the stamp, and that's university talk. It's no longer opinion.
Your Honor, in Hawkins versus Rhode Island Lottery Commission, the court there held that a statement has to be made by the person who is responsible for the termination, the person who is responsible for firing the person. And in this case, that's not the situation. They attached the letter for context, but even if this court wants to agree that they adopted the meaning of the letter, his claim still fails because it was truthful in nature. The true-false test utilized by the 10th Circuit simply requires that any allegedly stigmatizing statement be false in order to implicate a liberty interest. On page 24 of the record, the district court's decision regarding the application of this test relied on Bundren v. Perio, where a doctor sued another medical professional for filing an allegedly stigmatizing complaint. But the 10th Circuit held that it was not stigmatizing because it consisted of statements of opinion regarding a failure to meet professional standards, and the factual basis for those opinions were included in the complaint itself. Similarly, the letter attached to Dragontown's press release was the joint opinion of members in the medical community expressing concern about appellant's professional conduct. The letter merely reiterated the fact that his theory on the treatment of epilepsy was disavowed by the medical community at large, and appellant even stipulated to this on page 14 of the record.
So if Dr. Foster cannot prove that it was false, does he lose?
Under the true-false test and the stigma plus, yes, he would lose, Your Honor.
But but it's not just truth or false. You have to do the stigma plus too, right? So what if it's debatable? What do we do then?
Your Honor, the letter clearly expressed that his statements regarding the advice on the treatment of epilepsy were outdated, outrageous, and they used hyperbolic language as insane. This is not debated. On page 14 of the record, it has been acknowledged by both parties that the medical community, appellants, faculty members, colleagues also agree that this theory was not based in medical science.
But you heard Judge Culhane say that, you know, there's always a debate that goes on, and many people that have ultimately been found to be true went through terrible periods of being shunned and, and discarded in their professions because people had to catch up. So how do we deal with that?
Your Honor, the letter attached to the press release stated that the theory was outdated, which implies that it was at one point maybe utilized in the practice of chiropractic or in treating epileptic patients. But now in modern science, we are aware that it is not any longer a sound theory.
So if we just look at this as an opinion, can that ever be shown to be factually false?
Your Honor,
If that letter is an opinion of those people?
Your Honor, a statement of opinion will not be considered, a statement of opinion is not actionable if the facts underlying the basis for that opinion are included and clearly stated, and those facts themselves are not defamatory. The fact that appellant posted a theory that is considered outdated, outrageous, and insane has been stipulated to by both parties. Appellant himself acknowledged this, so it is clear that that is factually true, and that's what is underlying the basis for the opinions stated in the letter.
Counsel, ordinarily doesn't a hearing that satisfies due process ordinarily require notice of the action sought, copy of the charge, reasonable time for filing a written response, and an opportunity for oral argument?
Your Honor, there is no one exact formula for an employer to satisfy procedural due process, but
Tell me exactly what the email said.
it said we need to meet to discuss the recent allegations about you. Please contact me to set up a meeting as soon as possible, Your Honor.
So you said there's no specific test. I listed a number of things that generally are there. Was there a notice of the action sought?
Yes, Your Honor. The notice requirement was fulfilled in this case by the email sent to appellant because it clearly stated a need to discuss the allegations against him and instructed him to schedule a meeting to do so.
But didn't say he was going to terminate him.
No, Your Honor, but they did invite him to schedule the meeting.
They didn't, there wasn't a specific charge, was there? Did it say that you have violated our standards or anything like that?
No, Your Honor. The email was only in reference to the recent allegations against him, which was in reference to the media circus that had been following both him and the university for months. And any reasonable...
Well, it seems that what you're saying is he has to be prescient and he has to know what they wanted to talk about because there had been disruption. But how do you know that someone wouldn't come in and say, hey, you go, keep up your First Amendment rights? I mean, there isn't any indication we're calling you in so that we can terminate you.
Your Honor, as my co-counsel mentioned, there was a flurry of negative media attention, a student protest and class cancellation, a donor threatened to withdraw funds from the university, and there was backlash from alumni and the medical community at large.
Are we assuming that he knew all of that?
Yes, Your Honor.
What basis is there to assume that?
On page 13 of the record, Your Honor, it acknowledges that appellant was aware of what was going on when the trial became televised daily.
The record better than I. Thank you, counsel. What about, was there reasonable time, an offer for a written response before going into talk?
Your Honor, the email did say, please contact me to set up an email, and that is directed...
Set up a meeting or meet?
a meeting.
Right.
Sorry.
Okay, that's different than allowing some sort of a written response before you have an opportunity to talk about it.
Your Honor, they awaited 17 days before taking official action. So at its core, appellants...
What in the email, though, says what they're contemplating? if, you know, I could see where, you know, I mean, if someone said, I'm going to fire you, then I might want to talk about it. But if someone just wants to chat, maybe I don't really want to talk about it. Maybe I think I've got the right to do what I'm doing and they're not telling me they're going to do anything about it. There's nothing in there that says what Dragontown had in its mind, right?
Correct, Your Honor, but because due process is a situationally dependent standard, Dragontown's position is that any reasonable person in appellant's position would understand that the email could only be in relation to Dragontown's need to address his published theory on the treatment of epilepsy and his affiliation with the university.
I think one of the things my colleagues are suggesting here is that we talk about the hearing, but when we think of due process, we typically articulate it in terms of notice and an opportunity to be heard. This last part is what gave him notice that his employment as a tenured professor at the university was in jeopardy. That's what we're trying to elicit from you.
Your Honor, the context of the situation.
Well, but being tenured, I think that was something that Judge Culhane said. That's significant here. If he were an at-will employee and they said I mean, an at-will employee knows that they don't really have any right to be there, but tenure has significant protection. So doesn't that put more of a requirement on Dragontown to say specifically what the charges are that would override tenure? Because doesn't tenure, one of the principles for tenure is academic freedom, right?
Yes, Your Honor. The email did not provide explicit instructions about what was going to happen if he did not respond. This is true. However, the hearing that he would be entitled to is satisfied through post-termination proceedings. So if the notice in the email was insufficient, surely being terminated would be sufficient because his claim is about a liberty interest in his reputation, and the purpose of a name-clearing hearing is to have the opportunity to refute the charges against you. He was terminated on the same day that the allegedly stigmatizing press release was issued, and so therefore he would have had no reason to request a name-clearing hearing prior to his termination. His liberty had not yet allegedly been implicated. So having a hearing before he was terminated is logistically unfounded in this case.
Well, it kind of, if you look at the timeline of everything, since it was a very, you know, from my perspective, and I only speak from my own, we haven't deliberated on the case, but from my perspective, it was a very vague email. It doesn't say specifically what they intended. He knows he's a tenured professor. Doesn't it pretty much the fact that they just waited and they just did what they were going to do? It doesn't seem like they really cared what he had to say. If they really cared about what he had to say, they would have come back when he didn't respond and say, we need to hear your side of the story before we can make a decision. It doesn't appear they really wanted to hear his side of the story.
Your Honor, the invitation to set up a meeting, I can't speak for what exactly would be stated in that meeting, whether or not they wanted to hear his side of the argument or whether or not they wanted to hear a justification for the theory that he posted, but they did instruct him to schedule a meeting. So it's hard to say what exactly would be stated in this meeting, but we do know that the attempt was made on the part of Dragontown to extend that opportunity to him.
Counsel, our questions have taken up more time than you've been able to speak. So it would be nice for my assistance for you to kind of summarize your positions on why you feel that there was no due process violation.
Because he was afforded proper notice, appellant's failure to request the available remedy at the appropriate time was fatal to his due process claim. Though the Matthews test makes it clear that due process is flexible and situationally dependent, the Sixth Circuit has repeatedly held that due process only requires an employer to provide notice so an employee has the chance to request an opportunity to be heard. Under this analysis, a due process violation arises only from the refusal to provide the request in hearing. There is nothing in the record to suggest that appellant ever asked for this hearing or that he ever reached out trying to that he asked for one after he had been fired before filing suit.
Would it be your position that you could have just fired him without even sending that email out? What's your position on that?
No, Your Honor. The email was, in light of the context and the controversy that had been surrounding the university for months, the email was definitely necessary in this case to notify him that the administration needed to discuss with him what was being said in the media, what was being included in this medical malpractice trial, and what this meant for the university and his position moving forward.
Was there anything in this record that would indicate that there was a threat of imminent harm if they didn't allow a greater opportunity to discuss this matter and provide charges and notice and that sort of thing?
Your Honor, one donor had threatened to withdraw funding. We don't know exactly how much that funding is, but that funding could be used to go towards scholarships, so future students could potentially be impacted. It could go towards infrastructure and building new things, and so it's hard to say what exactly the imminent harm could end up being, but the withdrawn funds would certainly propose a very...
Well, it's a bad thing, but then
Yeah.
are we going to let donors dictate speech? Speech and money, speech and money. If you say what I don't like, then I'm going to pull my... So it seems to me great bodily injury would be more significant than withdrawing scholarship money, correct?
Correct, Your Honor.
Let me ask you one quick question if I can, because I addressed it to the other side. Of what materiality effect is it to you that the trial court judge said, I don't have any evidence of business loss or employment loss here?
Your Honor, that is blamed...
45 seconds remaining.
Your Honor, that is blamed on the appellant in this matter since he was the moving party. So the fact that he did not plead any facts that would indicate that he had...
You were the moving party on the motion below, right? It was
No.
Your 12B6.
Oh, yes.
It was your 12B6, and the judge granted it, but he said in the papers supporting in his ruling, there isn't any evidence of business loss here on the stigma plus issue. And will there ever be on a 12B6? Will there ever be any evidence? I mean, did he call that shot the right way?
Your Honor, I can't speak to that decision on that particular point, but at this point, reviewing the case de novo, we do know that there were no facts pleaded to suggest that he had even looked for jobs, so claiming...
Time.
But he said he wasn't working, right?
Correct, Your Honor. May I briefly
30
conclude?
seconds to summarize. Thank you.
Dragontown respectfully asks this court to affirm the district court's decision that appellant failed to state a claim upon which relief could be granted. Thank you.
Thank you. All right, I believe we have, 3 minutes for rebuttal?
Yes, Your Honors.
All right. We're prepared to hear that.
Your Honors, to protect plaintiffs' speech and liberty interests, two threshold matters must be met. Opposing counsel said we met neither, but both have been met. As a threshold matter for the First Amendment argument, first, we need to prove that this was not employee speech. Now, opposing counsel made the argument that because it was discourse on the blog, and because his job description included discourse, it was employee speech. However, that runs directly counter to Garcetti's own quote stating that formal job descriptions often bear little resemblance to the duties an employee actually has, and listing the formal job descriptions is not sufficient to demonstrate the conduct and task was within the employee's duties. Therefore, those quotes run directly counter to my opposing counsel's arguments, and they prove that it was not employee speech. Because it was not employee speech, the categorical rule does not deprive Dr. Foster's claim for violation of his First Amendment speech rights.
The reaction of persons to his advice in his blog were directed towards the university. Isn't that some indicator that it was perceived to be employee speech?
Well, Your Honor, that would once again fall under the Pickering-Connick balancing test, and when weighed against the larger public interests that was raised by the speech, it would unfortunately waver against and in favor of Dr. Foster.
So maybe I misunderstood you. You were arguing that it was personal speech, not employee.
Yes, Your Honor.
So I asked you a question about whether, not about Pickering, I just want to know, wouldn't that fact of the reaction of people that heard that be more indicative that it was perceived to be employee speech?
No, Your Honor, because Garcetti turns on the context and manner of the speech itself, not on the reactions that other people had to the speech.
So I mean, obviously, what's a university to do? You have, I mean, bedlam going on. Can they ever take that into consideration so that they can have some calm on the university? Or is that just, in this case, is that just bending to the mob? Or what are we talking about?
Yes, Your Honor, that concern specifically would not apply to Garcetti. That specific concern would fall under the Pickering-Connick balancing test, and we would measure it against the public interests and concern raised by the speech itself. Now, on the 14th Amendment issue, the threshold matter in that case was whether or not we can prove that there was a stigma and plus incorporated in the actual statement made. Opposing counsel argued that because it was a letter attached, it was not an actual explicit statement made. However, in Ulrich from the Ninth Circuit expressly held that the statement can either be explicit or implicit. In this situation, the letter is directly adopted and incorporated by the university as the underlying context and rationale for why they acted the way they did.
And so he had an opportunity to go and talk to the dean. He declined that opportunity or never responded to that. Why rather than a constitutional challenge, why wouldn't a separate civil action by Dr. Foster against the university for wrongful termination resulting in retroactive benefits be an adequate remedy?
Time.
May I finish? May I respond, Your Honor?
30 seconds, yes.
Yes, Your Honors. An action to address deprivation of his liberty, interest, and due process is most appropriate here because that is the origin for which his suffering has come from. His reputation has been tarnished in the medical community, and the facts stipulated that he has been unable to find employment since, which shows the plus is that he is no longer able to pursue future employment without government interference, which is the basis of his claim. Thank you, Your Honors.
Am I correct that would conclude the argument time?
You're correct, Your Honor.
So this court will briefly be in recess and we'll return with our decision.
You may be seated.
Let's hear a round of applause for our four advocates here. I can't imagine standing where they stood for the past hour and doing as well as they did and being unflappable advocates and paladins for their clients in front of that barrage of questions. So, congratulations. Well, while the judges are deliberating, we do have some other matters to tend to. What you see before you tonight is the beauty and the art of oral advocacy. But as many judges will tell you, many cases are won or lost on the briefs. So the briefs are as critical, if not more so, than the oral advocacy that the attorneys bring to the courtroom. So we recognize the excellence of brief writing with top brief writing awards. And a number of our students have been nominated for the Best Brief Awards. We have 2 Best Brief Awards for the appellants and 2 Best Brief Awards for the appellees. So the names of all of the nominees are in the program, but I'd like to announce our best appellant briefs. Hopefully they're in the room. Kelsey Thweatt. Congratulations. Thomas Gherini. And our best briefs for appellee, Dylan Musgrove. and Angela Fuentes. Congratulations to all of our awardees for the best brief. What?
Certificates.
Oh, yes. Yeah. We have lovely certificates suitable for framing for each of our Best Brief Award winners. So come on down and collect it. And we'll have a photo.
Thank you.
Ah, very good.
Thank you.
Thank you.
Congratulations.
Congratulations. Kelsey. Thank you. Tom.
How's it going, Professor?
Good. How are you?
Oh, you know, doing all right.
Thank you.
Thanks so much.
Thank you.
Congratulations, Tom.
Dylan's not here? No Dylan. Okay. All right. Well, while our judges are deliberating, I'd like to thank a few other folks whose efforts were absolutely instrumental in making this evening happen and making this year happen. And they are our GLS2 faculty. So, yeah. They are the foundation upon which this crucible was constructed. Daniel Croxall. Special commendations to him for his very thoughtful timing and cards tonight. Very nicely done, thank you. Mira Dalju. Adrian Carpenter McKinney. Aaron O'Neill Mullenberg. Rick Schickley. And two of our faculty members who were not able to join us this evening, but may be out there in YouTube land. Ray Tamadon. And Eitan Zaitsu. I'd also like to take a second to thank our teaching assistants whose efforts hopefully all of our students availed themselves of over the course of this year, and they deserve special thanks as well. So, Flora Fizey, Mo Ropley Navazio, Mamta Singh, and Stephen Weiss. And Brandon Nicholas. There's going to be a reception with hors d'oeuvres and beverage service in our Student Center directly following the award of our Top Oral Advocate Award. So I invite all of you to come and join us. Come and meet the advocates, meet our judges, meet our faculty, and spend some time with us. So until our judges are ready, mingle. This is the point where we get to know one another. Thank you, Jeff. Oh, thank you, Dan. That's for each of you too. In addition to I'm sorry. Right. Katie. I'm a little nearsighted. Hey, GLS props. Who are your props? Oh, okay. Hey, Mira.
What happened to our? I don't know. We have family tonight.
Anybody else?
I guess we're gonna, right there. Right there. Move up just a little. Slide over just a touch. Slide over.
Very nice.
I don't want the flag sticking out of your head. It's working.
Really.
Right there. Very good.
Thank you. Thank you. It's relieve a little bit of.
All right, here we go.
What you went through. That was really strange.
I will grab.
Very good. Thank you.
That was a hot bench. Good job. Yes.
And I felt like you guys. My goodness.
Yes. I mean, not even a sentence. Very good job.
Yes.
So I appreciate that. Yes, Allison, you did a great job.
Yes.
I didn't want to say anything before you argued because I didn't want to disagree. I didn't want to upset you.
I figured it was coming. So I had an idea in my head of what it was going to look like, and it looked nothing like that. But I didn't know that. So it was exciting.
That's fair.
Okay? Let's put you right here. Next.
That would be great. Yes, let's get Steven. My TA. Steven was
is he here?
part of this. He's right here. Yes.
Oh, okay, yeah, for sure. He's the only TA who's here.
Oh, okay. It's been so outstanding.
Wow.
So
You have to smile and look good.
Yes, I remember that.
it's been a remarkable.
Yeah. Oh, that's good.
He definitely.
Very good. Thank you.
I missed that part. I know, right? But I'm very happy for you. Yeah, I hardly contain Can I get a picture with my students too? Sure. Who are both super bored. Can I be the board that got
Move up. Move up. Right there. And slide over. You're not sorry. All right, now slide over. Right there. Right there. Don't look at her, look at me. Very good. Don't stick out your tongue at me. There you go. Thank you.
Yeah,
Very good. Let's do that one more time. You're blank. You're blank. You're blank. All right, here we go. It's kind of like you mean. There we go. Much better.
Thank you so much.
I know it doesn't mean, but you're also good at
You ready?
Yeah, give me money. Sorry.
You're not. There we go. Fair. Very good. Like that. Very nice. Thank you. Thank you.
Yes, yes, and
A lot of questions that you got that were just very like broad, not very specific.
yes.
I tried to go back.
Yeah.
Pull that out.
You're like, bring it back.
That's usually all
Advocates, I wanted to let you know, in addition to the level
I had no idea.
well, I think what they do anyway.
Up there, no, Your Honor. Awfully hot in here. You couldn't tag. I was like, oh, this is cool.
They're very old.
He did not seem like it.
So many people complaining about the front line too. It was like teachers running away and a dragon running and coming down, and she goes, "You're teaching 8th grade." And like, it should be funny. Because we kind of do. And it was kind of like, if we don't kind of do.
That was always the thing. It's like, you just kind of just have to honor it. Yeah.
Well, I need to tell our other advocates
You
about
just kind of hope that you get the nice names and not the easy.
I wanted to mention that in addition to the level of framing of the certificate, there's a package.
I always wanted to make sure. I thought, okay, ceremony. Everyone and I was millions of dollars.
Oh, that's what I was
Yeah. $1 million less.
I love that. I mean,
Something like that.
Yeah, that's right.
Hey, I'm Jeff Frosty, Professor Frosty.
We've met probably, well, it was over Zoom a lot. Yeah.
Probably on Zoom.
Yeah, I was.
The argument.
Oh, okay.
Same as last year.
Oh, okay.
There you go. Stephen knows.
I got to you at the end. I was like, is it not okay to go woo?
Yeah.
I clapped
That's the
very
thing.
hard.
I was like, can I whistle? I go.
And I was like, how intensely can I hear you?
If you go to Downey Brothers,
Yeah, it's a golf crowd, this baseball crowd. Like,
they will bring you back. They will post-bar you. They want that in the office. You want to post-bar. Nah, I put mine on the desk.
This is remarkable. I don't know that I've seen other than they were so intense.
really like hot
Fired up.
Yeah.
Yes. Oh my God. Yeah.
That's when the sweat started kicking in.
Yeah. Oh, you really kept your composure.
Sorry. I'm glad it's like that outwardly. On the inside.
Supernaturally calm.
On the inside, there was a lot of confusion in it.
Wow. Well, that was actually.
Thank you. I'll give credit to my beginning acting professor in college. I actually did the, because we had to do a monologue in that class. Getting the closing argument.
Wow.
I figured it was good practice. Yeah. So he was,
I like I came in here like really early because I wanted to.
being in
Still though.
it was really fun getting to do the whole dramatic. It doesn't make you miss it. And all so it was fun.
That's good.
This is the only acting.
You should be like a little bit of it.
That was the only acting.
Oh, I mean, really though.
Other than that.
And now this.
And now this. I'll add that to my resume.
I was in Houston. It was working, but it was very funny. It was a lot of fun because the competition. Really?
Yeah.
It is fun. Yeah.
We still got our fun. But it was all.
2020, we just didn't went on at all. Figure out how to do Zoom.
Right.
So now it's
Last year,
Apply for extra.
Oh, yeah.
On Zoom. I remember.
yeah, last year we
I really want to work with our Chinese somewhere. I really hope.
it was all on Zoom.
It was all on Zoom. Yeah, it was my office.
After all these things, I went
And amazingly, they were still aggressive on Zoom.
Yeah, they were still pretty.
Still aggressive.
Yeah, I got through my roadmap, but after that, it was all hands.
I was not anticipating a theme statement to get in.
Right.
I like, you know, when you're moving and questioning you, like, and everything. terrible trip to the Monday to Thursday was tragedy. I'm on the underside. The word was it about the speech itself? She really wants to know about the sales. Look, you have to speak there.
Oh, right.
Bad idea.
Yeah.
Okay. You ended up getting stuck.
Right. There are.
Let's talk about that.
Right.
Well, I'm gonna get them.
Right.
Listen to word choice.
Yes.
A word like that.
Yes.
And it's one word.
Yes.
There.
Yes.
You got any big tie?
Yeah.
Waving at us?
It's not jumping out at me.
Not yet.
But for them, it's like right there. You said very big.
Yes.
Yeah, that was very big.
All right, hey, Tom.
Right? Yes.
Careful with those like semi-legalistic words.
Right. Maybe that hook was maybe too big. We were meant to bite that one.
One in-person final, and I have two ears, which are due.
The ball? Oh, yeah. That was, yeah, the giveaway. That was actually kind of helpful. I'm like 6 words in. Order in the court.
Okay.
The Court of Appeals for the 14th Circuit is now in session. All rise. Sorry, MP. You may be seated.
Well, we want to thank all four of you for excellent presentations. Is this on? Can you hear this? Okay. Well, we will eventually announce our decision. It was a very difficult decision because all of you were absolutely excellent. And we're going to give you some comments as to your individual performances and things that we noticed and things. But I think that we can say 100% here that all of us would welcome you in court and that you're better than 90% of the people that we see on a regular basis. That no one would ever think that you're a law student. And I'm going to be in court all next week, and I'm going to be thinking of all four of you and hoping that the people that appear in front of me live up to the jobs that all of you have done. You were very well prepared, very facile with the law and the facts, and you should all be very proud. And that made our job very hard. And I guess that's what we get paid the big bucks for, but not enough. So I'm going to go to my colleagues and allow them to get more specific, and then I'll make some closing remarks. Justice Scotland.
And we aren't always mean and nasty like that, except we just wanted to see, courage under pressure and all of that. So I just made notes about each of you, but I do want to reemphasize that it was a very, very difficult decision because you all did just a bang-up job, really, really excellent job. So I'll start with in the order that everyone spoke. So John, you were very poised, very confident. You were very respectful. You had a great knowledge of the law. You had very good responses to questions and knew the facts. Just to kind of tease you in a little way, at one point there was a question from the presiding judge about, wouldn't this be a difficult point for your client? And you said, yes, Your Honor. I think that was a transition into answering your question, but it was essentially a concession that you quickly dispelled because your further answer was not, yes, Your Honor, that's a difficult point for my client. Your rebuttal, I mean, you were not directly responsive to one of my questions, but then you became responsive. So listen carefully because I know all of you want to make a point, and you can try to spin a question into a point, but try to be as directly responsive to the question, and then you can put your spin on. But overall, I thought you were very impressive, very, very impressive, no doubt about it. Allison, do you mind if I call you by your first names? Okay. So you were very poised, you were passionate, you were obviously very confident in your argument and your position, which is a good thing to be. You knew the case law very well, you knew the facts very well. You got some difficult questions and you backed off. I could see you nodding. Yeah, they were difficult. Yeah, you didn't back off, and you did it very respectfully and very confidently, and had a great grasp of the case. Just two comments, and it's a little different in the trial court than in the appellate court. You want to avoid making overstatements. Like you start out saying, this is a flagrant violation, and I jumped on you just because I wanted to give you a hard time. But at the very end, you said, and it's clear. So much in the law is not clear. I would read lots of briefs from my over 20 years in the Court of Appeal, and the use of the word clear was so often when it wasn't clear, okay? So don't overstate, don't use adjectives or adverbs that are unnecessary to the point you're trying to make. That's just my 2 cents. That's from my perspective. Maybe not everybody agrees with me, but you just don't want to face a cranky judge and go, what do you mean this is flagrant? Anyway, but I thought you were very, very talented and very, very good. Heather, you were, as with everyone, all of you really knew the case law, and all of you really knew the facts. In fact, you did a very good job in itemizing the harm to the university, and you just had that, and just boom, 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 and you did it in a very, very compelling way. You were calm. You got asked difficult questions as well, and you were. You actually have all had the best eye contact. When you were answering a question, even though it was one justice, you would look at all of the judges, and that's a very good technique and an effective technique, and one that most attorneys really don't do, and I thought that was very, very good. Your opening statement, can't remember what it was a little overstated about
She got me riled up.
Yeah.
over killing someone.
Yeah. So hyperbole, you always have to just be careful, okay? Just be a little careful not to overstate things, because if a judge is having a cranky day or just wants to give you a hard time, there you go. You got it. So don't, just look at the facts and the law and make your case without trying to be too, hyperbole or overstate things like that. Is it Katie? Is that okay? You were poised, very professional, had a very impressive presence. You were calm. You answered questions that were long and didn't ever seem to be frustrated. There's sometimes, I'll never forget a case that I was doing, and I was asking these questions, and the experienced appellate attorney said, Your Honor, I'm bristling at your questions. I said, well, gee, maybe we just shouldn't ask you any questions. But at any rate, you didn't bristle. You were poised, you were respectful, and you answered the questions. I probably would have liked to hear a little bit more from you, because our questions were taking up so much time, but I thought you did an excellent job. You all did very, very good jobs. You should all be very proud of what you did. You all have what it takes to be really good appellate lawyers, so kudos.
Thank you.
Thank you.
Judge Culhane.
Thank you. Well, what I was thinking, and much of what I would say will repeat or maybe amplify a little bit of what Justice Scotland said. But what I was thinking when we were talking about this case was that for me, this is 46 years of teaching here. People ask all the time, why are you doing that? Why do you keep going? We just, last night, it's getting a little harder to get up the next day. than it was at the beginning. There's the answer, Dean Schwartz, sitting right there, those 4 people. And for the audience, those 4. That's the answer. That's why we do it. That's why everybody at the school does what they do. And I endorse what Judge Callahan said, that we don't see people as capable as you 4 very often. And Justice Scotland talked about the fact that, the use of hyperbola is probably a little less welcome at the appellate level than at the trial level. The trial level, and we talked about this in the other room, see it all the time. I think we get this desensitized to it at the trial level, but it is important on appeal that it's a little bit different forum. We're not having the gladiators actually in the well at the moment, at least putting on evidence. So, in terms of going through this, I thought you opened the case in a terrific way. I agree with Justice Scotland that you had a real facility with the cases. And on appeal, that's the ballgame. I mean, you made, a lot of the factual arguments will all be in the briefs, but what cases say appellate counsel need to be able to pivot and modify and jump like you did, and I thought that you did a terrific job with that, good with the authorities. The pace of your argument, particularly the first time around, was very measured, so that we're not trying to keep up, it was very deliberate, and I thought very effective as we went. Allison, again, I'll call you by your first name just because I won't say all the last names correctly. I thought as well, you had a great facility with the cases and comfortable on your feet. There were 2 moments for you that I made a note. One, the question was asked to you, can the attached letter be defamatory? And you jumped right on that question and went directly to the restatement of torts and announced the rule that I hadn't thought about in 40 years anyway, that, if an opinion suggests the existence of underlying supported facts, that can be defamatory. And I thought to myself, whoa. And then secondly, and I couldn't remember from my notes, it was later in your argument, a question, I believe it originated with Justice Scotland, pushed you on a point, and you very adroitly held your ground, and you didn't get pushed off of your mark, legally, if I can say it that way. And so, again, the question of, picking on people because of the hyperbola, I leave to folks to my right because they deal with that. And I think those are all meaningful comments, certainly. Sometimes if you understate your case, you do better than if you overstate your case, I think, in appellate arguments. So, and I got to argue appeals in front of both of the people in front of me next to me when I was a lawyer. So, when they're gone, we'll so let me come to Heather, if I can. Again, apologies for using your first name, and mean no disrespect to any of you. Once again, I endorse what Justice Scotland said. I made note regarding your eye contact with the members of the panel, which I think is important. You seem comfortable in your skin and with your argument in terms of interacting with us, even though these things were coming at you. And you also were able to go right to your bank of case law, and at one point looked at your cases to make sure you had the name exactly right, which I thought, that happens. That's real life. You did it the right way. Really good. And then, Katie, let me come to you. I do think that you got more questions sort of fired at you, but there's a learning point there. In other words, you got a little less time to speak thematically, but there's a learning point there, and I know that Judge Callahan will speak to this, but on an appellate argument, that's what you do. In other words, you may come in, and certainly to prepare for an appellate argument, you have to know all the bases, legal basis, but rarely do you have to argue them. Rarely do you get a chance to argue. And so on an appellate argument, a lawyer may spend their entire time just answering questions. Sometimes they don't even think they're important questions, but that's the appellate lawyer's job. You said the important points once in your brief. This is oral argument, so now a big part of it is just responding to whatever the justices have on their mind. You had a lot of tennis balls coming over the net at you, and you know, I thought that you know, you had to pivot more frequently, or at least you know, answer more frequently, and you seem to be very confident with the case law and with the essential points of your argument, even though we pushed you off of the thematic argument a bit. Don't think that's unlike what happens in appellate courts. It does. Okay. So those are my comments to everybody, and turn it back over to Judge Callahan.
Well, once again, I would say that you were all fabulous. And one of the things that, you know, some of the things that we're talking about in terms of, because we're judging you as advocates, we're going to give a few points there. But none of you did anything that would have won or lost your case. And I will tell you, for the most part, I think from my perspective, and I can't speak for everyone, I thought that Dragontown had the harder case to me than Dr. Foster, but I'm pretty vibrant on the First Amendment as far as that goes. But but I don't rule on cases, but I recognize that as advocates, sometimes if you had the harder argument, and you made points with me, sometimes that can be good. So whether you had the easier or the harder or the more appealing, I thought all of you did justice to your own arguments. I was a trial lawyer. I wasn't an appellate lawyer before I became an appellate judge. So I certainly have done I've indulged in hyperbole. I've lit it up, and I get pretty excited. And so that I didn't catch the flagrant nearly as much. You know, I am going to say that, you know, Heather, you had me coming out with because I had thought that through. And on appellate work, I will say that the understatement is you came back from it, and that would not have won or lost. But I think, and I have to fight this myself. The understatement in appellate work is really more important than the overstatement, which I am so good at as I was as a trial lawyer. So, and I think, you know, Katie, one of the things that really, when you come in, I didn't mind at all that you just had to answer questions, because one of the things that you have to realize is these three people are going to decide your case, and you're not coming in, you really aren't, it's different than what we're doing here. We're judging the best advocate, but you're really coming in to make sure that the people that are deciding your case have their questions answered, and that you don't in any way indicate to them that you think that they're annoying, irrelevant, or you're off the point. I mean, and you were very poised about that. And I think all four of you, one of the things, it's terrifying to go to court. I mean, I've been terrified so many times, and I didn't see any crack in any of your armors as far as that go. You really were so calm. I mean, I've seen people in court that you ask them a question and they freeze, and they don't answer it. And then I've tried to help them with an answer. And what I liked about what all of you did, I thought you kind of thought all the angles. You know, what can you lose but still win? And that's really important, and that shows a real sophistication, and you all showed that. And so, and you know, John, one of the things that's really, I've judged a number of moot courts all over the United States, and a lot of times it's hard to be first out of the chute, and I see nerves on people, and I didn't, you know, you were ice. Iceman there. I mean, you really were completely relaxed. And I think all of you really were grace under fire in all the ways. And so I'm very impressed. And any of the things are really, none of you lost your case by anything that you did. And you had all the law, you had all of the facts. And if you deserved to win on the law and the facts, you would have in that situation. So I'm very proud of all of you. And I recently was at Harvard, and Harvard had nothing on any of you in their moot court finals. So and I sat with Justice Kagan on the panel, and I thought both of you were just as good as Justice Kagan. So. So you should all be extremely proud of yourself. And so I have the hard job of, as I said, we really talked a long time about it, and really the time really flew. I think that we can all say, I was really interested in everything that all of you had to say. And sometimes oral argument can be like watching paint dry. And you were all captivating. So thank you so much for giving us the opportunity to see what you're capable of. And with that, I will announce the person that we've selected as the top advocate, and that is Kathryn Lerseth.
Thank you so much.
So are we done? Is court in recess?
Excused.
Thank you very much, judges, for your excellent commentary and your service this evening. I'm sure the students and RGLS faculty and all of our supporters and family in the room appreciate what you've done for us tonight and your insights into the arguments. I invite all of you to join us at the reception in the Student Center immediately after this. We'll have a moment or two for some more photos. If our judges would permit, perhaps they'll stand for some photos with our advocates. Sure.
Are you going to do it here, or can we take that, can we get rid of the robes, or what are we doing here?
With the robes here?
Sure.
Yeah, how about here with the robes,
Okay.
real fast? And the rest of you, oh, yes. Thank you. I lost my line for a second there. Gifts for our judges.
I love these.
Yes. A whole collection of things for you.
I'm retired, so I don't have to report this on my FPPC stuff.
I don't think you will.
So if you're not taking photos, head on over to the Student Center for some refreshments, and we'll see you all over there.
Is there a?
Oh.
Oh, I was just.